If 539 had been in place, if it had been law when the initiative petition was brought to the council, is there anything in 539 that would have prevented it from going ahead and be presented to the voters? In other words, would the initiative process not have just continued as it did, even if 539 was in place?
No, I think that the initiative process would have continued forward, but I do think that the impact subsequent, which is city pays, if there is an impact,
right, not getting there, but
would put a significant chilling effect on such things as whether or not
they would have voted for it.
Whether or not they would have voted for it, or
so if people had known, if there had been a fiscal impact statement and an impact statement regarding how it affects public education, that would have had a dampening effect on whether or not the election would have passed.
Perhaps. Perhaps.
Okay. And so I guess back to the original question, is there anything in 539, if it had been in place, is there anything that law would have, is there anything in place from 539 that would have prevented the initiative election from going forward? Recognize it may have changed the outcome of it, but could the election still have been brought by the citizens, and could they have still had a vote on the ordinance?
I don't think it limits the ordinance being crafted and going forward to vote, but it's the city pays provision again.
Right. I understand it would have a dampening effect, might change the outcome if people knew how much it might cost.
Fair enough.
That might change the outcome of the election.
Fair enough.